Any mention?
May I please, Lordship,
Yes.
I beg to mention item number 12, Lordship.
Yes.
Lordship, I am praying 2 weeks' time, Lordship.
Why? Who is the other side?
No objection, Your Lordship.
What's the matter about?
A service matter, Lordship.
No interim order here.
No, Lordship.
On prayer made by the learned counsel for the petitioner, not objected to by the learned G. This is matter after when?
2 weeks, Lordship.
2 weeks. This is matter. Yes.
Obliged,
Obliged,
Lordship.
Lordship.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 10, Your Lordship.
Yes.
Your Lordship, I humbly pray kindly this matter may be listed after 2 weeks, Your Lordship.
No objection, madam. For the respondents number 4 and 5.
Same order. 2 weeks.
Your Lordship.
Yes.
Your Lordship, similar prayer for item number 20 also, Your Lordship. We have already informed the opposite party also, Your Lordship. Mr. Paske is appearing in this matter with the opposite party, Your Lordship.
Yes. Just say 20 on prayer made on behalf of the petitioner. List after 2 weeks.
Hello,
Yes.
Lordship.
Lordship, I beg to mention item number 16 and 17 for 2 weeks, Your Lordship.
What is this matter about?
This is Ms. Nigrim's matter regarding the certificate. Character 1 is a character certificate.
No objection, Lordship.
16, 17, 2 weeks. Yes.
May I please, Your Lordship? I will beg to mention item number 23. Your Lordship, I'm praying for 1 week time, Your Lordship.
I have no objection.
1 week is okay. Yes. 20 is on the prayer made on behalf of the petitioner. List after 1. Yes.
Much obliged.
Please, Lordship. Lordship, I beg to mention item 15, Lordship. I'm praying for some accommodation.
Yes, Mr.
Come over 2 weeks, Your Lordship, then.
15 also. On prayer for the petitioner.
Lordship, in this matter, I am referring for respondent number 4, Lordship. Lordship, I have instruction in this matter, Lordship. Respondent number 4 is not interested to pursue this matter, Lordship. Therefore, I humbly pray, Lordship.
See, that we will see whether you are interested or not. We will see at the time of this thing. You are respondent, isn't it?
Yes, Lordship.
So on your prayer, we cannot close the writ petition, can we? We cannot.
Much obliged, Lordship.
Yes, this was 2 weeks on prayer. Yes.
Please, Lordship.
Yes.
I would like to make a mention of item number 18, Lordship.
Item 18. Yes.
Praying for
Yes.
2 weeks' time, Lordship.
No objection. 18 is 2 weeks on the prayer. Yes.
May it please, Your Lordship. Lordship, I beg to mention item number 7 on behalf of Mr. P. Nongri, Lordship. Lordship, I pray for 2 weeks' time.
On behalf of Mr.
P. Nongri.
Is appearing on behalf of?
Respondent number 4, Lordship.
What is this matter, Mr. Thank you?
No, this is about the erection of boundary pillars between 3 Akings.
Okay, dispute between 2 villages.
2 Akings, madam.
2 Akings.
Akings.
Okay, Garo Hills.
Garo Hills, madam.
So,
I have no objection, madam.
the prayer made on behalf. You are appearing for the district council. Prayer made on behalf of Mr. P. Jungni, Lorded Council, appearing for the respondent number. So and so. Not objected to by Mr. Thank you, Lorded Council, appearing for the page. This is matter after 2 weeks.
Much obliged, Lordship.
Much obliged, madam.
Causeless, item number 1.
This is an application for quashing the proceeding. The matter is pending before the IO for last 6 years, my lords. In the year 2019, FIR was lost.
Pending before the IO means?
With the police investigation.
Okay, this is investigation.
FIR was lost in the year 2019 and till date it is not yet finished, my lord. And in the
What is the offence involved?
mischief and theft.
Mischief and theft, and it is
Pending for 6 long years, my lord. And as a result, I even qualified for the post of Gram Sivak, but I could not be appointed because of the pendency of this investigation, my lord.
325 is also there.
Yes, my lord.
325 is also there.
Yes. But there is no ingredients of the. It's all right.
Can that be a ground for quashing in law?
Yes, my lord. There are some judicial pronouncements which says that such a long pending matters should not be kept long pending for so many years, my
Okay,
lord.
that goes a normal proposition. That will be probably a right under Article 21.
Yes, my lord.
But then whether that can be a ground for quashing, that is what is to be said.
It will be heard, my lord.
Yes, madam.
Lordship, in fact, this was brought to light before the JMFC, Lordship. If Lordship could kindly go to Annexure 5, page 18.
Page 18.
Page 18, my lord, of the petition.
Oh, there is some order also.
Lordship.
Yes.
This is 29/8 of 2025, Lordship. So in this order, Lordship, the JMFC had directed the IO to expedite the investigation and to file the report accordingly, Lordship.
That is a recent order, 29/8.
Yes,
Exactly, very recent, my lord.
And no time fixed, just expeditious.
And just madam, you take instruction, just see
Lordship, and there's also a private party here, Lordship.
private party.
Private party, Lordship.
The complaint, my lord.
Oh, okay, for question. Okay, heard Mr. Siddiqui, Learning Senior Counsel, assisted by Mr. Inuta. Notice returnable in 3 weeks. MSNG Sheila Learned Senior PP APS for this. Respondent number 1, state respondent number 1. Petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. List after 3 weeks.
Much obliged, Lordship.
Item number 2.
May it please your lordship. My lord, I seek indulgence of your lordship to kindly have the matter after 2 weeks since the conducting counsel is out of station, your lordship.
There is no one is there at the other side.
My lord.
None appears for the petitioner. On prayer made by Mr. Jirwa. Learned Counsel with the respondent. This is made after 2 weeks.
Deeply obliged, your lordship.
Item number 3.
Yes.
My lord, we'll just request another 2 weeks to file a reply here, my lord.
Acha, rejoinder.
Rejoinder, my lord.
Yes. Rejoinder against the.
My lord, we will be filing a rejoinder.
Again, rejoinder against the
counter affidavit filed by the complainant.
state has filed a counter affidavit here.
State lordship.
No. The rejoinder is against whom?
Against the
private,
R2.
Counter affidavit was one number 2.
My lord. We'll just file a rejoinder to it and matter is ripe after that, my lord.
Okay, on prayer made by Mr. Khera. Learned Counsel appearing for the petitioner. Another 2 weeks time is granted for filing a rejoinder against the affirmative opposition. There is number 2. Yes.
Apply.
Item number 4.
Have you filed that? Yeah.
No, charge sheet we have just not received. My lord.
Yes.
My lord, here we have to, the development which had happened was that the charge sheet has been filed. So my lord was of the view to proceed ahead in the matter, since we have also a miscase for staying the proceedings, that it would be wise to go through the charge sheet. So my lord, we have not been able to obtain the charge sheet as yet. What was obtained was an incomplete copy without annexures. Now we are on the court. So my lord, 2 weeks may be given. 3 weeks may be given, so that because it's coming from Garo Hills, we'll file this.
Okay. Mr. Khera, Learned Counsel for the petition submits that the complete copy of the charge sheet be obtained by the petitioner till date, and he is for grant of some more time for filing an affidavit to bring it on record. Stop. The Learned Counsel appearing for the respondents of no objection. prayer alert list after 3 weeks.
3 weeks.
My lord, also the private respondents have filed their
VC through VC. Yes.
My lord, they have filed their affidavit.
Oh, yes.
My lord, if required, we will also file a reply to that.
Okay. No, but then
They have filed a
it's a criminal petition.
No, because they have brought some new facts.
We'll see at the time of hearing. If it is requested, you see, we will not make it.
Lordship, my lord. Because they have come up with.
That will be never ending. Then
Lordship, I'll just make a mention. Lordship, I'll just make a
my lord.
mention. Not even a single fact has been averred out of the charge sheet, Lordship.
Okay.
All
We'll
the
see
things
it.
have been mentioned.
We'll see it at the time. Okay.
Item number 5.
Yes.
It is not sure.
What happened?
Lordship.
Yes.
As per the last order, they are supposed to inform regarding the status of the inquiry report. Counsel, Mr. Sengut, I was appearing that he's supposed to bring some instruction.
Oh, yes. Yes, yes. Yes.
Today's division, waiting the division, Lordship, I have it at the end of the board.
No, we have to know about the status
Yes.
of those cases.
My lord, I have received the status from the police, my lord. So,
What is the status?
status is that investigation is not completed, my lord.
It's a case of which year? 2017.
My lord,
And then how much more time you will take for investigation?
May I submit, my lord, a copy?
What is this case of, Mr. Sangma?
This is where I have been suspended, alleging that I have worked as an enforcement director, but there is no enforcement officer. The enforcement post was not there. However, I was promoted to that post, and the CEO himself has said there is no post, and they allege me that I have some kind of misappropriation of some fund. But suspension not on that ground. And there is a FIR, both the parties. I also filed the FIR against them, and they also filed the FIR against for
You filed the FIR against whom?
Against the officers for misappropriation of fund. Then there was a both party approach in the High Court.
So how do you know fund has been misappropriated?
Yes, that's why there is a direction from this Honorable Court to inquiry from the both parties. From the case has to be investigated from.
What is this? What is the summary of this? One second. What is the summary of this, Mr. Sangupta? This is a huge thing.
My lord, certain allegations were against this very person who is the petitioner herein in this case, my lord.
Yes.
And for playing with the accounts of the Bagmara Municipal Board, my lord. So the officers had filed FIR, and there is a counter FIR, my lord. And pertaining to that, the investigation has been going on. But then due to non-cooperation, it appears, my lord, the investigation is still not complete.
Due to non-cooperation? Of? This entire investigation is not dependent on the cooperation of the petitioner only.
My lord, will kindly see page 3, my lord, of the report of Bagmara Sadar PS case.
There was a ministerial inquiry.
My lord?
There a ministerial inquiry?
Yes, my lord.
Where is the ministerial inquiry thing? You know about that ministerial inquiry? There was a ministerial inquiry.
No, that I don't have any knowledge.
You are Robert T. Sangma, isn't it?
Yes.
That was taken into consideration by the IO.
You just supply him if there is no problem, supply him a copy, Mr.
I have no problem, my lord, since
just supply him, let him also go through that and have this instruction. See, Mr. Sangma, this report, it speaks of a ministerial inquiry report of Srimati T.K. Sangma MCS, and it is found that Sri Robert T. Sangma has not handed over charge and cash books, passbooks, bill register, assets everywhere to Sri Brighton G. Momit. You are Robert, isn't it?
Yes.
And who is Brighton? Brighton.
Brighton is a private respondent.
Private
yes,
respondent?
What in the petition.
Why there
because
is a
he was appointed against my vacant post as a LDA. I was working as a LDA. Then they removed me.
Then they promote you to a non-existent post.
Where there is no post.
And then vacancy created is
occupied by this private respondent. Now they are saying that I am supposed to.
What is the affidavit of the district council?
Not district council. This.
Who? Oh, municipal. Where is the affidavit?
Municipal.
This is a case pending from 2018.
Yes, the affidavit is there, Lordship.
This kind of cases remaining pending for such a long time. What is the affidavit of the?
Their affidavit is maybe on record.
By respondent number?
Their respondent number 3 to 4.
3 and 4.
3 and 4.
There is a affidavit dated 18/8/2022. Is that what, Mr. Dev, your affidavit?
Yes.
Yes.
18/8/2022.
Yes.
Yes. What they have stated in their affidavit, Mr. Sangma? Insofar as that issue is concerned, what you are saying about your promotion to a non-existence post.
Regarding the affidavit which they have filed, they have never mentioned regarding that enforcement post, my lord. They are only alleging me that I have misappropriated that para 7. The statement which is leading the performance is checkbook. The same thing only in the affidavit in the para 7 also they are stating that I have not handed over those accounts, checkbooks, etc. custody without handing over to the newly appointed head assistant BG Moment. BG Moment is a private respondent.
Read para 6 or there of their affidavit.
Lordship. The statement made in the para 5 to 7 are most borne out of the matter of record as such required no comments to made such extent. However, answering respondent begs to state that the allegation that petitioner was promoted from the post of head assistant UDA to the post of enforcement officer is illegally entirely baseless, misleading, concocted, and denied. It is pertinent to mention that the petitioner was given the charge of enforcement officer in the best interest of the public, and the same was purely a policy decision of the board. In fact, the petitioner himself had approached the previous chief executive officer for appointing his as an enforcement officer, and the said
just show us that this post of what was this post. There is a service rule.
No, there is
no service rule of the municipal.
Lordship, there may be.
Municipal board. Now, how do we decide the issue whether there was a post was in existence or not in existence? Now, if you say it is not in existence, then you have to show us that such post was never created.
The CEO himself was in my region that they have clarified, Your Lordship, that this post was never in existence. In my affidavit, not the rejoinder, whereby the chairman of the Bagmara Municipal Board on the letter 25/6/2017, he has made it very clear, Your Lordship. He has written, this is his own letter, my lord, where it says that FIR on.
Where is that letter?
That in my rejoinder, page 22. Page 22 is the type copy. The original is.
In your rejoinder?
Yes, my lord. He is the chairman, Bagmara Municipal Board, South Garu Hills. There is signature.
No, but then there must be a service rule. Where is the service rule?
Page 22, my lord. That is a letter.
This is a letter dated?
Letter dated 25/06/2017. It's a type copy.
Just a minute. Your rejoinder.
Yes, Lordship. Read, Your Lordship.
What is their response to this letter? What is the?
They have not. There is no response to
yes,
this
Mr.
letter.
Who is it? Yes, Mr. Deb. What do you say about this letter?
Regarding that, my lord, specifically we have not said anything, my lord, about the post. We admit that, my lord. But what was the reason for his suspension? My lord, we have stated.
No, just what do you say about this letter? This is a letter by your chairman.
Yes, my lord.
And it says that no post was created.
Earlier also I have seen.
You show us the service rule.
There is no service rule, my lord, for the municipal. Service rule, my lord, they are contemplating to formulate.
Then who creates the post?
It is by the board, my lord itself. They take a resolution, my lord.
By which way?
By a board meeting, my lord.
Then you file an affidavit.
My lord. First and foremost,
Showing see, this is very difficult for the court to determine this situation and in absence of any service. Then it is required upon you to file an affidavit saying whether this post was at all in existence or not. And if you say it was in existence, then you have to support it by relevant resolution. What you say of the board.
Exactly. That has to be done. Because this letter, which my friend has produced, my lord,
Yes.
Whether this was taken only by the chairman or by the board, that has to be examined also.
That is what for you to respond.
Kindly produce para 8 of my affidavit. This is not the only reason for a suspension.
That is all right, but then see, if we can determine whether this post was in existence or not, that would be good enough. Other issues will follow automatically.
Oh, one thing, my lord, whether the post was in existence at that point of time, that I have to take a fresh instruction on this and file an affidavit to the effect. The only thing is, my lord, that I want to place, my lord, on page 7, what he has done, my lord. 12 lakh rupees from the board money was illegally withdrawn by him, and an FIR was lodged.
By him means in what capacity?
He was also taking care of the account, my lord, at that point of time.
But that is what. So you see, your contention that he was taking care of the account is only on the basis of the fact that he was promoted to the post of informant.
No.
That is.
No, my lord. He was not promoted to the post of accountant. He was holding a dual charge was given to him, my lord.
That is what this.
That is our point of view. My friend says the moment that dual charge was given, the charge which he was holding, the permanent charge which he was holding, according to him, my lord, it was given to the private respondent, and he was promoted or he was given a charge, and he remained in that.
Was there any departmental proceeding too?
Yes, my lord. There was a DC has conducted an inquiry, my lord.
Where is that?
That is what, my lord. Now everything is before the police. They have seized, my lord, from
No. What about your department? If you say that he was indulging in some malpractice or manipulation, then there has to be suspect.
My lord has to give me some time.
This is 2018 matter, and these are the main points which is to be decided, and these are absent.
Last occasion, I have prayed before this honorable court that, my lord, there was some department proceeding, and also there was an FIR, and the papers or files were seized from the office, my lord. That is what.
See, so far as the police thing is concerned, Mr. Sengupta has already produced report, and it appears that it is still pending.
Still pending.
2017 case, but then it doesn't mean that your department should also, you see, just remain dormant like this.
The difficulty that we face, my lord, because at present, my lord, the CEO, she has been recently transferred or given the charge, or she was appointed.
You are talking about present. See, Mr. Dey, incident happened in 2017, and now we are in 2025.
So that I have no
8 years.
argument, my lord, to place before this honorable court for the lethargic way this things was dealt by, like. This letter, which was issued by this chairman also, my lord, it speaks volume. One hand, my lord, the board is saying that you have done something wrong. On the other hand, he comes and clarifies. Now, he is a political man. The chairman is a political man. Whether this was his point of view or it was the board's point of view, that also has to be ascertained.
That, see, all are political. Whoever is there in your thing, they are all
No, my
political.
lord.
And
CEO
there are any
is not a
non-political elected member there.
CEO is not a political identity, my lord. She is an MCS officer.
So that argument may not hold much water. You see, the thing is that
Unless my lord, give me some time to obtain the file and to place the proper facts, my lord, before this honorable court, it will be very difficult.
so you want to say that the issue whether there was whether a post of informant officer was in existence or not has nothing to do with his suspension.
My lord, without getting the proper instruction, it will not be proper for me to submit.
There is
Because
an-
I cannot, once I submit, my lord, I cannot withdraw.
There is an affidavit filed by you. Thereafter, what instruction you need?
We have filed an affidavit on the instruction of the officers, my lord. Now, this, no doubt, my lord, that affidavit is very much silent on whether the post was there or still there or not, my lord. I totally admit on that part, my lord. I have no argument to say that. But, my lord, we have also highlighted what is the conduct of the petitioner and what is going on with the petitioner case, my lord. only thing, my lord, what verbally I was informed, my lord, because the files and all has been seized by the police. And police is also, my lord, placed that the matter is pending inquiry. For that, my lord, we are not in a position to, my lord, take a final call on him. So if, my lord, give it 2 weeks time,
how can you make a person suffer for such a long time, saying that this all the papers are seized by police and all?
my lord, give me 2 weeks time. I'll take a proper instruction, and if my lord, also my lord, allow me to get the details of the files from the police itself, my lord. If there is an order reflecting, my lord, that we need this to ascertain that, then that file can be produced by my lord's friend also.
This case appears to be, it's a puzzle, you see. We do not know how much this court can help the situation. Perhaps there has to be some sort of inquiry conducted in these things, some independent thing.
DC can be directed.
Not DC. We'll do this thing. We'll tell somebody, the premier investigating institution. Dr. Mujika is there. Perhaps we may tell his department to do. No. See, that is this appears to be very the petitioner's contention. This you can come forward just one step. Here the thing is that of course we do not know the court should discuss it or not. But then the thing is that petitioner says that he was promoted from the post of LD to the post of enrollment officer, which was not in existence. And by promoting him, the vacancy created by me was fulfilled by a private respondent. And thereafter, he has been charged of doing manipulation in the promotional post, which was not in existence. And the material record doesn't say whether that post was in existence, it was not in existence, and it is pending from 2018 like this.
His post, someone has been appointed already.
The private respondent occupied.
Now, we have to have some sort of, anyway, Mr. Dev, you have your instruction. We'll just see what is required. If not, then we have to probably take help of Dr. Mujika's thing, at least to make the department present before us.
Can I take for 3 weeks time, my lord, so that everything can be clarified? I will be in a position to submit something before this honorable court.
This affidavit is filed by you, isn't it?
Yes.
It is not by any other counsel.
No. There's no doubt about it, my lord. But what has fallen from my lord, the core issues, that has to be placed, my lord, address whether there was a post created or not, and who has created a post, whether the board has created or the urban affairs department has created a post. Those things, my lord, because there are multiple authorities, I have to seek instruction from all of them.
The problem for this court is there is a 2018 case. And if you give you again time for taking instruction, then what happens to the affidavits which are already in the record? Is it not proper for the court to just decide only on the basis of the information which are...
But since
No, then you say because you are asking for time. Now, if you have to decide on the basis of that, then it's a fit case where some inquiry has to be held. If your department is not disclosing everything to you, then it has to be, disclosure has to be obtained through somebody else.
It is not that the department is not disclosing. They are saying, my lord, certain files which are in position of police, my lord. Because of that, they are not in a position to give the proper instruction. It's not that, my lord, department has any interest to hide anything.
My lord, what I can instruct my IO, my lord, is that to provide them with the certified copy, Xerox copy of the documents which are, if they seek for it,
it is not at all the concern of the court, you see, which way they do it, which way they do not do it. But then we are interested to know what is happening.
During the investigation, my lord, even I am very much handicapped. I cannot direct how the IO is to act, my lord.
No,
I can make a request that to expedite as early as possible.
See, Mr. Shangipta, so far as the issue before this petition is concerned, you do not have much role to play.
Very limited.
Except for telling us about the outcome of
the investigation.
Otherwise, we are right now concerned with the
Since my learned friend is saying that certain documents are with the police, my lord.
Dr. Mujika, you can take your place. You see, you can take your seat. Sorry, you are not supposed to say.
So, my lord, they definitely will be provided with the documents if they apply, my lord. Copies will be supplied, my lord. Originals may be retained by the police.
That is how you do it. You see, like that is basically for them to make a request to you and then do it. His court's order is not needed, or neither You see, which way you do it, you can do it.
Without the court's order, my lord, whether it will be proper on my part also to instruct
That
the
is,
IO.
you know, see, the department has not asked that till now. If they want it, they can file an appropriate application, then we may pass orders.
I bow down.
But then, the court is not there to, you see, like, make a case for these things. The court is basically interested to know the actual fact. Now, what Mr. Sangma says is very serious. If that be the thing that promotion is made to a non-existent sport, and his post is filled up by somebody else, and thereafter departmental charges are brought against him of mishandling the accounts. Now, if at all after his promotion he was not discharging function, where is the question of himself giving indulgence in manipulation?
My lord, that is where, my lord, the IO will have to do hard labor and find out.
That is the
what happened to
criminal side
fund.
of the thing is concerned.
Yes,
but then
my
once
lord.
department has decided to suspend somebody, that must be on the basis of some
That
matter,
is
isn't
his
it?
civil right.
Where is your suspension order, Mr. Sangma?
That is the page
Let us see what is
36
the
of the repetition.
page.
36, Annexure 16. Even they said there is a report, even that also they have not furnished to me.
What is that report? Is it there on the record?
It's not that
This is on the basis of the report.
Yes, on one page they have, that report is not furnished to me.
Have you asked it?
I have asked your lordship, even the respondent also have not filed this report.
What is the proof that you have asked?
They have requested his lordship,
Verbal request. You go to the office and
Request.
ask for, please give it to. Is it it?
But in my representation, I make it clear.
The thing is that, okay, what you say, so far as about the existence of post and all, it may prima facie have something, but then this report otherwise is prepared on the basis of an investigation by a team constituted by district collector, deputy commissioner. So it is not the action of the district council. Oh, sorry, action of the municipality. This report has not been placed on record, Mr. Day.
No, because one more inquiry is there. That is what I was saying.
But then that inquiry is the backbone of your.
Yes, ma'am.
So it should have been there.
We can place it, ma'am, by way of additional affidavit. We'll bring it to record.
Okay,
And this
hard.
has been conducted by a magistrate, ma'am.
It's hard, Mr. Petitioner. Well, I had learned the council appearing for the parties at some length. The contention of the petitioner, paragraph, the contention of the petitioner is that he was appointed as UD What is the department of chairman, Bagmara West Garo Hills? What is department of chairman? Your paragraph 2? Now,
Chairman, he should be
now
municipal.
it becomes difficult for the court also to.
Municipal, my lord. Yes.
Where is that? Department of chairman, Bagmara.
Chairman. Lordship is a mistake. Below
No,
down I have
your
written
mistake creates trouble for the
municipal, Bagmara municipal board. my
Yes.
lord. Down. Department chairman actually should be the municipal. Bagmara
The case of
municipal.
the petitioner is that the case of the petitioner in brief is that he was appointed as UD in the Bagmara municipal board. and Municipal Board on 27/2/1990. Okay. See, you were appointed at the time. It was not municipality. It was a town committee, which was upgraded later to municipality. You should say it. You were never appointed in the Bagbara municipality initially.
Yes, sir.
There's a problem, Mr. Sangma, with your petition. You were appointed by the chairman of the Bagbara Town Committee. Just probably you have to correct it, write it again. Just think. Just say in the case of the petitioner is that he was appointed as he is appointed to the post of upper division assistant in the office of the chairman, Bagbara Town Committee, by letter dated 27/2/1990. And thereafter was transferred. You have been transferred and regularized by the same order.
There is a different order, madam. There is Annexure 2 is there.
No, there transfer and regularization is by the same.
Yes. Yes, that is same.
Yes.
On 27 June 1995. In the same order.
And there was transferred and regularized as the way UDA in the office of the Bagbara Municipal Board by order dated 27/6/1995. Where is that letter dated 31/8/2015?
31. This one is Annexure 6, page 25, madam.
Page 50?
25.
25.
31 August 2015.
How we started the first line of the starting? Okay. It's okay. It's all right. Just sit down. It is stated by the petitioner that during the course of his services, an UDA in the office of the Bagbara Municipal Board, he was. But then see, Mr. Where is the promotion? This is not promotion, isn't it?
No promotion.
This is.
Yes, if that is the case, they should not have appointed the private respondent in my
That
place.
is a different issue. But then you said this is promoted and.
Is promoted, but
Where is that promotion order?
there is no promotion, Lordship. But this is the only that.
You should be
put me-
penalized, for misleading court. You should be penalized. And this is not only one case. It will be repeatedly happening in one of them. This is not something. Take note. Take note of all those things. Until and unless you come clean in the court, you will have problem. Just cancel all those things. The challenge made in this petition by the writ petitioner is that consequent to his is that he was we say challenge made by the writ petitioner. No. The contention of the writ petitioner in this case is that he was promoted to the post of enforcement officer from the post of UDA in the Bagbara Municipal Board. And thereafter, the post held by him as and post vacated by him. The post of UD vacated by him was filled up by appointing the respondent number 4. Stop. It is a case of the petitioner that the post of enforcement officer is a non-existence post. But despite the fact he was charged with financial irregularity. Financial irregularity?
Yes.
And suspended from service. And you are charged and suspended from service on that account or on that ground. Stop. In support of his contention that the post of enforcement officer was a non-existence post, a letter dated 25/6/2017 brought into record by you of an additional affidavit. Record is so and so issued by chairman issued by then Chairman Bagbara Municipal Port, South Garo Hills, comma, brought into record by an additional affidavit, comma, has been relied upon by the petitioner. Step. Paragraph जिसे Mr. Day, London Council applying for the District Council. Oh, sorry, for the Municipal Board. Is the respondent number? Applying for the respondent number 3 and 4. On the other hand, contended that the suspension of the petitioner has taken place consequent to an inquiry conducted by conducted on behalf of, where is the suspension letter?
Yes, it is page 6.
On behalf,
That is page 36.
Yes, what
Suspension.
is it? Last? Was made on the basis of an inquiry report submitted by so it's by investigating officer constituted by. That is what is the language used here.
Executive magistrate
Was submitted by the investigating officer appointed by on the basis of appointed by the district collector / deputy commissioner. Stop. However, it appears that the said inquiry report is not a part of record. In this case. Stop. Furthermore, the information with regard to the fact whether the post of enforcement officer was in existence in Bagmara Municipal Board at that relevant point of time is also not clear. Stop. Paragraph J. Faced with the situation, Mr. Day prays for grant of some time to have elaborate instruction on the elaborate instruction of the matter so that relevant point can be placed before the court. Relevant point for consideration in this matter can be posed before the court. Relevant point, just give a comma, particularly whether the post of enforcement officer was in existence or not. Comma can be placed before the court. Stop. Prayer allowed. List after 3 weeks. Then you before that, and the first part of the order, just before you just say, you say in terms of the last order, Mr. In terms of the last order, step, Mr. Sangupta has, Mr. Sangupta, learned additional senior PP, has placed on
Status report.
has obtained status report of Bagbara police case number 31/6/2017 and Bagbara police case number 32/06/2017. You'll find these case numbers under these things. You do not have to write the sanctions on the order. Has what is it? Has obtained instruction?
Has obtained status report of
Stop according to the learned additional PP. You are additional senior PP or additional PP?
Additional PP.
Additional PP, huh? Make it correct. The above cases are still pending
Yes.
investigation. Yes, there is no cooperation from the side of the petitioner.
Yes, that is one of the contributions.
Is it there? Provided here?
Yes, my lord. I'll read out, my lord.
Anyway, yes, there is no cooperation from the petitioner. Stop. Does it say how much more it will take time?
No, my lord. Last paragraph, my lord, I will read out. Since I am the new IO of this case, the case is pending for proper study and thereafter the case
That is a very common stand that he is the new IO. The cases are pending for these things. Every 5-6 months you change, new IO comes.
May I provide them with the copies of the status report, my lord?
It's up to you if you think. Do you need?
Yes, Lordship.
Please furnish them.
This is one.
There are two status reports, isn't it? Two cases.
Yes, my lord. Two status reports. I have provided my.
You got it, Mr. Sangwa?
Yes.
Both the cases?
Yes.
31 and 32, just see. Reference on the top.
Yes, I got it, Lordship.
Later on, don't come and say that you have not received. The said status reports were placed before this court. Our place before this court, not our place before this court. Stop. Then you give paragraph and then you start from the next paragraph, okay? Yes.
Much pleasure, Lordship.
Item number 9.
Yes.
Please, Your Lordship. Lordship, I'm seeking for some accommodation on this matter today.
My lord, I have no objections.
On prayer meet on behalf of petitioner. This is matter after 3 weeks.
Obliged, Lordship.
11.
It's not objected to by the Land Council for this.
Lordship, we were supposed to produce a copy of that one-time settlement scheme on this matter, Lordship. We'll need some more time on this.
My lord, the matter was heard at certain point of time, my lord. And then Lordship has raised a query regarding one notification, whether they fall under the scheme, my lord, because they have come later. So they were supposed to bring that on record, my lord, or not necessary to affidavit, my lord, but they were supposed to take instruction on that scheme. And this order was quite long, my lord. Quite a long time back it was passed.
It was passed a long time back.
Yes, my lord, quite a long time. And since then the matter has been adjourned, my lord.
Okay, order is on 3/7/2025.
Yes, my lord.
So it's not very long. It's this year only.
No, my lord. In the sense, after that, the matter has already come 4 times, 4 to 5 times. 5 times the matter has come. They were supposed to bring that.
It appears that the Land Council for the petitioner has not placed a copy of the settlement scheme of 2020 contained in memo number. Just see memo number, you note it from the order dated 3/7/2025. Okay, dated 4/11/2000. What is it? It appears that dated 4/11/2022. Memo number so and so, dated so and so. Okay, dated 4/11/2022. In terms of the order dated 3/7/2025. In terms of the order dated 3/7/2025 of this court. Yes. The Land Council today the Land Council for the petitioner has prayed for grant of some more for time for producing the aforesaid. What is that? Scheme or memo or what is it?
One-time settlement scheme.
Order dated 3/7. Is it? What is it? Today the order has prayed for grant of some more time to produce the copy of the aforesaid scheme. Stop. The Land GA. They paying for the
My lord,
state.
not as GA. because it's MACL case, my lord.
Okay, the learned counsel. Miss R. County learned counsel appearing for the. You are appearing for the respondent, all the respondents?
All the respondents, my lord.
Appearing for the respondents. There's no objection. Prayer Lord, list after
3 weeks, Lordship.
after 3 weeks.
Obliged, Lordship.
13.
Lordship, I'm appearing on behalf of Mr. R. Jha on this matter today. He's having some personal difficulties, Your Lordship.
No objection, Lordship.
The prayer has been made on behalf of Mr. Arja, learned counsel appearing for the petitioner.
Lordship,
Urging the
13
matter.
and 14 are connected, Lordship.
Wait, let us pass the order, then you say to adjourn the matter. Stop. The prayer has not been approved by Ms. Sogro, learned counsel appearing for the respondents. Prayer allowed, list after 3 weeks.
Obliged, Lordship.
19.
19 also same order. 19 also same order. Then, okay.
13 and 14.
Same order. Same prayer, same order.
So this is a
Yes, what is this matter about?
To quash the FIR, the criminal.
That CBI
Yes,
investigation.
yes. Your Lordship, on the last occasion, Your Lordship, I have some authority with me, Your Lordship, to submit, to support my submission, Your Lordship.
What are those authorities? What is the order? What is the order passed by the trial court? You have not taken us to that.
To frame charge, Your Lordship. To frame charges against the.
Where is that order?
petitioner.
Where is the contents?
Page 350, Your Lordship.
Yes.
Lordship, senior is on legs before courtroom number 1, Lordship.
So what is to be done then?
Lordship, he'll be coming, Lordship, he's coming.
Lordship, the impugn order is at page 342.
The operative part is at page 350, Your Lordship.
Lordship, this is the order rejecting the discharge application, Your Lordship.
Yes.
So, Your Lordship, in my humble and respectful submission, Your Lordship, it is reversible and not by court.
So what you will say about Prabhu Chawla case?
Lordship?
About the proposition of law laid down in Prabhu Chawla's case?
Lordship, in fact, give me that mic. Lordship, in fact, this is a 3-judge decision, Your Lordship.
Just give her also a copy. If you have, or at least give the details. Okay. This is 2022 decision. Yes, madam, see this. This one.
Lordship, just.
Yes.
I don't. Only 2 copies, you mean? Sanjay Kumar Rai.
Which part you were referring?
If Lordship kindly come to para 12.2. Lordship, kindly have 2.2 second. Lordship has got
Yes,
it.
para 12.2.
12.2, Your Lordship.
Yes, second, yes.
May I read it, Your Lordship?
Yes.
Second, this court in Asian resurfacing, while expressing concern
regarding the need to tackle rampant pendency and delay in our criminal law system is followed the ratio laid down in the earlier decision in Madhu Limaye versus State of Maharashtra, as can be seen from the following extract. Thus, even though in dealing with different situations, similarly conflicting observation may have been made while holding that the order framing charge was interlocutory order and was not liable to be interfered with under 397(2) or even under section 482, the principle laid down in Madhu Limaye still hold a field. Order framing charges may not be held to be purely or an interlocutory order and can be in a given situation be interfered with under section 397(2) or 482 or article 227 of the Constitution, which is constitutional provision, but the power of the High Court to interfere with an order framing charge and to grant stay is to be exercised only in exceptional cases. In Madhu Limaye, this court authoritatively held, sometimes the provisional jurisdiction of the High Court has also been resorted to for the same kind of relief by challenging the order taking cognizance or issuing processes or framing charge on the ground that the court had no jurisdiction to take cognizance and proceed with the trial, that the issue of process was wholly illegal or void, or that no charge could be framed as no offence was made out on the allegation made or the evidence adduced in court. Even assuming, although we shall presently show that it is not so, that in such a case an order of the court taking cognizance or issuing processes is an interlocutory order, thus it stands to reason to say that inherent power of the High Court cannot be exercised for stopping the criminal proceeding as early as possible instead of harassing the accused up to the end. The answer is obvious that the bar will not operate to prevent the abuse of the process of the court and to secure the end of justice. The level of the petition filed by the aggrieved party is immaterial. Lordship, kindly see para 14. The correct portion laid down in Madhu Limaye thus is that the order framing charge or refusing discharge are either interlocutory or not final in nature and therefore not affected by the bar under section 397(2) CRPC. So it is revisable, Your
That is
Lordship.
okay, but then even for 482 also is maintainable. That is all.
Lordship, the finding at paragraph 14 is very clear, Your Lordship. Lordship, kindly have again
It
paragraph
doesn't
14.
say. See the Prabhu Chawla. Have you seen the Prabhu Chawla?
Lordship.
See the Prabhu Chawla. No,
This is also
these two order operates in two different fields. The question is that whether availability of a revision, remedy of revision under 397 will bar a petition under 482 or not.
Lordship, if there is a specific provision,
that is what we understand the normal thing.
To challenge a certain order passed by the by the district judiciary, Your Lordship. In my humble and respectful submission, Your Lordship, that has to be followed, Your Lordship, as laid down by the Sanjay Kumar Rai, Your Lordship, in paragraph 14.
You go through this Prabhu Chawla's thing, and then you come back and say.
Lordship.
Because Prabhu Chawla's decision also, which she has relied upon, is 2016. This is also a 3-judge bench. Now that also you have to go through.
Lordship, let me have because it's a question of law, Your Lordship.
Definitely, this
Question
court
of
also,
law,
see,
Lordship.
what you say, that is the normal proposition. We also, probably this court also thinks
Lordship,
that is correct.
Another aspect of the matter is that if the charges has been framed, Your Lordship, whether a 482 will, Lordship, that also there is a 94 decision of the Supreme Court, Your Lordship.
Okay. What else?
If Lordship, kindly.
These are all striking at the maintainability. So you should have argued it fast before she argued.
If Lordship kindly have para 7. Because this charge has been rejected, mostly these charges must have been framed. Lordship, kindly see para 7. If charges are framed in accordance with section 240 on a finding that a primacy case has been made out, has been done in the instant case, the person arraigned may, if he feel aggrieved, invoke the revisional jurisdiction of the High Court or the session judge to contend the charge sheet. I know, Lordship, whether charge has been framed or not, Your Lordship. Certainly it must have been framed, Your Lordship. charge have been framed. So, Your Lordship, the remedy is, if charges have been framed, Your Lordship, the remedy is by 397, not 482, Your Lordship.
If charges are framed.
Lordship, yes. Kindly see para 7, Your Lordship. Para 7 of this judgment. If charges are framed in accordance with section 240 CRPC, on a finding that a prima facie case that has been done in this case, Your Lordship, the learned trial court, Your Lordship, came to a finding that there is a prima facie to proceed with the trial of the case. As had been done in the instant case, the person arraigned may, if he feels aggrieved, invoke the revisional jurisdiction of the High Court or the session judge. The language is very clear, Your Lordship.
See, madam, see further this paragraph 7. Have you received a copy of this?
Lordship, I have given that copy, Your
Just
Lordship.
come. Just read the entire paragraph.
Proceed.
It further goes to say about the justification of exercise under jurisdiction under 482.
Lordship, that the charges have been framed under on 28/8/25, Your Lordship. Lordship, do you have extra? Lordship, kindly have a look.
But my lord, I've come before this honourable court not only to quash your lordship the order of the judicial magistrate first class. I've come before this honourable court to quash the FIR and all the entire proceedings, your lordship.
We understand, but then the fact remains the charge has been framed, and that framing of
During pendency after the criminal petition, your lordship.
that is all right. But then the whatever the thing, see, like the fact remains the charge has been framed. Now, if charge has been framed, then it has been here provided that see, nor it would be justified to invoke the inherent jurisdiction of 482 CRPC to quash the same. There also that has been done. Now, the thing is that this is a decision which Mr. Sulai has given. The second one, this is a 2-judge bench, and the Prabhu Chawla is a 3-judge bench, isn't it? Prabhu Chawla is a 3-judge.
Three, your lordship.
Now, Prabhu Chawla basically is a case where, because of two divergent views of 2-judge benches, the Prabhu Chawla matter was referred to Prabhu Chawla. Now, whether this Madhulimaya case was there, I think there. Mr. Sulai, please see that part.
Lordship, if this matter can have on some other day, Lordship, I'll go through that 2016 judgment, whether that Madhu Limaye has been referred or not, Your Lordship.
Madhulimaya was referred in Prabhu Chawla.
But in Sanjay Kumar Rai, in that 22 judgment, that has been referred.
So we'll have it next week then.
Next week,
you just also go through.
Yes, lordship.
Please see, because your decision which you have given is a 3-judge decision.
Yes,
So
yes,
definitely, all right. But then only thing is that the decision which Mr. Sulai has given, the second decision, which is more specific to the fact that once charge is framed. Now, Prabhu Chawla case, whether that is specifically on that or not, that is to be there. That is what is to be seen. Plus, Madhulimaya,
because Lordship, admittedly, Your Lordship, the challenge here is against the order rejecting the discharge application, Your Lordship. So, in that view of the matter, it is reversible before the land session judge, Your Lordship.
That was the view of the court also, but then she countered it by giving that Prabhu Chawla.
Lordship, that
is the initial view.
Judgment, Your Lordship, that is of
but then
because it said that it is no bar, Your Lordship. The legal bar is not there, Your Lordship, under 397(2), Your Lordship.
It is not even there is another decision 2024. That is a 2-judge bench decision, and it says that when there is a specific provision
Lordship,
cannot
yes.
come under prohibition.
That is my
Now,
submission, Your
perhaps that was the thing, but then the provisional says something else. Otherwise, this court was initially not entertained. She has
Lordship,
she has compelled
I'll
the
do
court to
some,
entertain.
since it is a question of law, let me do some research, Lordship, on that aspect of the matter. If there is a specific provision, whether for it would be maintainable.
Yes, Dr. Mochika, what do you say? You will be.
This is a very grey area. It's a very fine line, my lord.
Do not know. See, with due respect to
my lord,
whatever thing is that, the normal understanding is this law provide for specific provision, then that must be available. If there is no specific provision, then only the question of invoking inherent power comes.
Yes.
That is what. But then now many decisions are coming the many way.
Because the decisions are again based on facts also. Because one of the decisions which I was going through, they are trying in 482, they are trying to rely on some additional documents. Then Supreme Court said you have to base the argument only on the basis of the document that were available for the trial court. You cannot introduce new documents. Then again, Supreme Court says unless it is unimpeachable. Yes. If it is unimpeachable, it can be taken into account.
That means like admitted documents. So the things are changing. So we have to basically, and of course, evaluation is something which is continuous. So law also see.
So broad principles are there, my lord. Broad principles of law are very clear. But to apply to the facts of the case, that is what.
Otherwise, this case, when this matter was argued by the Land Council for the petition, the court was not very inclined to this thing. But then she came with that proposition of provisional offence. That is what.
To submit very fairly, my lord, because the issue raised by them that CBI will not have jurisdiction after Prevention of Corruption Act is dropped. Because if that is the plea taken, my lord, in my humble submission, lordships can entertain this 482. To be, that's what I understand, my lord. Now it's up to the lordship whether.
Lordship,
though Mr. Chula is a different argument, my lord.
We'll have it on next week. Meanwhile, Mr. Singh.
Then another aspect also, Your Lordship, because here, admittedly, Your Lordship, the intention is against the employee of the central government. Whether that section 6 will come into play, Your Lordship, when the issue is involved a central government employee.
This will Dr. Mojika will reply. Right. You see, you are not to put question to the court. See, you have to solve it. You have to
Lordship,
give the answer.
Lordship, I have come across there is a decision regarding that
for central government employee.
Lordship,
this bar poses it.
From a state office.
Probably you are correct.
I'm looking in that decision, but I'm not getting a Lordship.
Probably you are correct.
There is regarding a railway official from West Bengal, Your Lordship. Yes. Some courts say, since he is a central government, the concern of the state under Section 6 doesn't arise, Your Lordship.
So we'll have it on next week, and now you have more points to prepare. Well, even that about the central government employee. Now that becomes an additional point. That was not argued by you on the other day. So you have to counter that also if at all they come with any law.
This one I've done.
Yes, states thing will be confined to state things. We'll just have it on after a week then.
Let it be after a week, Your Lordship.
Yes. We'll just simply adjourning it. You just also raise these issues. Yes.
Or next week, Lordship, there's so many holidays.
Oh yes, next week there will be
Next week from I think only 2 working days, Your Lordship.
Well, a week starting from 10th in that week.
You can have on 11 or
so
11
say it
or
after just list it only a week after 10th. No, the week commencing from 10th. That can be done.
11th.
Today is what date? Even if you say after a week, it will go through that.
Today is 27th.
Yes. Okay, on prayer made by the parties.
Yes. He's a railway official.
This is matter after 1 week. After 1 week, you keep it after on 10th.
After a week.
Highly obliged, Lord. 22.
This list this list given. These are all on the question of maintainability.
Yes.
All on the question of maintainability, or other issues are also there.
And also in the ingredients, Your Lordship. Also on the ingredients.
As it is. So you'll have to address the court on those things because you have not addressed those.
Yes.
So your argument is not also over.
Obliged, Lord.
Yes.